innocent grandma kidnapped by U.S. Marshals, game wardens caught trespassing on land, and a man arrested for asking a trespasser to get off his own porch. All that and more on today's IJ Update. In the blink of an eye, Penny McCarthy's peaceful day of yard work turned into a nightmare. A 66-year-old grandmother, Penny was on her driveway in Phoenix, Arizona, when a team of U.S. Marshals pulled up in unmarked vehicles and aimed rifles at her. The officers threatened to hit or tase her if she even looked at them, placed her in handcuffs and ankle shackles, and drove her away from home. The officers did not so much as look at Penny's driver's license or run any basic checks on her identity before violently arresting her.
I said, "Who are you?" And he's like, "You know who we are." Around the corner came 3 unmarked white cars.
Police, don't move! Hands up!
And people were hanging out the side, pounding on the side, saying, "Police, police, police."
Hands up! Turn around. Turn away from the sound of my voice.
The next thing I knew, there were 6 armed people pointing rifles at me.
Stop moving and stop looking back. Stop looking back!
Who am I?
Turn
away.
Turn around, we'll discuss it.
Turn away, you're gonna get hit.
There is a terrible mistake going on here. They're like, "You know who we are. We know who you are." I'm like, "Who am I?" They're like, "Carol Ann Rozak." I said, "That is not who I am."
Now, IJ is representing Penny in a major federal lawsuit. Under Arizona law, the officers committed multiple civil wrongs, called torts, including assault, battery, trespass, false imprisonment, malicious prosecution, and negligence. Under the Federal Tort Claims Act, an individual can sue the United States government directly for certain harms committed by federal employees. Penny's video has been widely watched online, and we've gotten thousands of comments. Here are a few. So the person they were looking for, they were wanted for a non-violent crime 20 years prior, and they sent a tactical unit to do it? This is pure insanity. A simple asking for ID would have prevented all of this. People need to go to prison for this. QI needs to be rescinded. One commenter asked, how did the feds think this woman was the person they were looking for? Were they just driving around and saw an older lady and think, that's her? Here's IJ attorney Marie Miller to explain.
So these are all really good natural questions. And to start, it is absolutely insane that the U.S. Marshals would use so much force going after a person who's wanted on a 25-year-old warrant for failing to check in with a probation officer for all nonviolent crimes and after being released from prison for them. Now, as for the question about how the police officers wound up targeting Penny McCarthy, the U.S. Marshals really don't have a good answer. So what we do know is Carol Ann Rozak went by the maiden name Milligan, but she also apparently used other aliases, including Mary Leslie Pye, Leslie A. Tanner, Susan Rigler Sherman, Penny Lee Burns or Barnes, Marilee J. Graves, Diane Allen, and Sandra Evans, and possibly others. Now you see, Penny Burns is one of the names that Carol Rozak may have used. But Penny McCarthy has never gone by Penny Lee Burns or Barnes. Her maiden name was Penny Burns, but only for the first 17 years of her life. And that's where the commonalities between Carol Ann Rozak and Penny end, other than the fact that they're female and approximately the same age. But hundreds of people have that much in common with Carol Rozak. Hundreds of people have the same name as one of these listed names, and hundreds of thousands of people share part of their names with one of these names. So hundreds of thousands of people in the United States have as much in common with Carol Ann Rozak as does Penny McCarthy. So apparently the U.S. Marshals were simply looking around on Facebook, looking for people who share part of their name with one of these names associated with Carol Ann Rozak, and they came across Penny McCarthy's profile page and picture and thought, oh, she's a woman who may be about the same age. That's the best that the U.S. Marshals have, and that is simply not good enough.
Now, moving from injustice in Arizona to injustice in Alabama, officers from the Alabama Department of Conservation and Natural Resources routinely trespass onto private land without consent, a warrant, or even a reason to suspect a hunting violation has occurred. Officers ignore fences, gates, and no trespassing signs, treating private land like public property. Shockingly, an Alabama statute allows this. That statute relies on federal precedent. About a century ago, the U.S. Supreme Court wrongly endorsed the open fields doctrine, which holds that, except for your home and a tiny ring of land around your home, Private land doesn't deserve Fourth Amendment protection from unreasonable searches. The Alabama Supreme Court, however, has never endorsed the federal open fields doctrine, and the Alabama Constitution protects against unreasonable searches of all possessions, including land.
The first time I ever learned of a game warden being on my property or having any interest in the property is when I found one of my cameras turned to the side and the other camera was watching the same field. I had pictures of him walking around and snooping around the woods without ever saying anything, without ever contacting me.
That was IJ client Dalton Boley. Now, Dalton and others have joined forces with IJ to strike down Alabama's warrantless entry statute so that all Alabamians may be secure in their own land. People naturally understand that game wardens trespassing without a warrant is a violation. I would feel so violated if I caught anyone trespassing on my land, especially if the game warden was snooping around seemingly for no reason. Thank you all for challenging this. As an Alabama resident and landowner, I want to be secure in my private property. My first reaction is, this is America, get off my property. Unbelievable encroachment. And Chris Smith had a great question. Absent probable cause or a warrant, how does the state have a compelling interest when it comes to private property? And take it away, IJ Senior Attorney Josh Wyndham.
Well, it doesn't. The whole point of requiring officers to get a warrant based on probable cause is to have them go to a neutral judge and really show their work, demonstrate why there's a reason to think there's a compelling governmental interest at stake on that property, the violation of a criminal law, for example. And if we don't have that crucial check of a judge being involved in the process, then our private property really isn't secure. Officers could come on whenever they feel like it, jump our fences, roam around for hours, put cameras in our trees without any real limits. And under our Constitution, private property means more than that.
If game wardens can walk onto someone's yard with no warrant, then no one's land is safe. And when an officer does get a warrant to search your property or arrest you, it must be based on facts, not vague rumors or untrustworthy hearsay. After all, a warrant gives the police extraordinary power. The power to arrest someone and take them to jail. The power to raid a home. The power to seize possessions. Michael Mendenhall was arrested for asking a trespasser to get off his porch. Then Denver police used sketchy, secondhand information to get a warrant, search Michael's townhouse, and seize his property. Like a high-stakes game of telephone, the testimony of a dodgy witness was passed from the actual witness to a police officer, to a detective, and only then to a judge.
So I opened up the door and I found a couple ladies quickly departing, and I said, what the hell's going on out here? And I said, just get the F off my porch. And the guy just started, really mouthing off and backing up at the time. And so it was a very, very quick encounter.
It wasn't until days after his arrest that the charges against him were finally dropped. However, the police continued to hold on to the property they seized with the bogus warrant. Michael, with the help of the Institute for Justice, is suing to overturn bad legal precedent that lets law enforcement use secondhand information to get warrants. But the Fourth Amendment's text demands first-hand knowledge, that a warrant be supported by oath of affirmation. Without it, the founders' constitutional vision is obscured. Here's a few comments. If the complaint the warrant is based on turns out to be false, the person making the false allegation should be charged with perjury. That gives the falsely accused some recourse. Judges need to be more inquisitive and not just rubber stamp these warrants. I grew up during the Cold War. This was one of the critiques about the Soviet Union, that anyone can accuse you of a crime, and that will get you arrested by this flimsy evidence. I think it's an important idea to have confidential informants swear before a court before issuing a warrant. We also had a compelling comment from Christopher Kidwell. Sorry, but I disagree here. Numerous cases against the mafia and other gangs have been based majority on secondhand or even third-hand information, then buttressed by evidence gotten with a warrant. Judges should be allowed to say, the suspicion here is reasonable, and even though this is second, third, even further information, we are going to allow a warrant. I hear you, and so did IJ Senior Attorney Patrick Giacomo. Here's his response.
Thanks for the comment, Christopher. Now, I could be an obnoxious public interest litigator who works on the Constitution and say, it doesn't really matter what the policy effect is. All that matters is what the Fourth Amendment requires. But in the example of a complicated case like one trying to take down the mafia, This actually is something that doesn't require an additional amount of effort that's a lot for the government, because they can use things like pseudonyms, John or Jane Doe, or they can seal documents or use a number of other techniques to make sure that witnesses' firsthand information is the thing that's actually supporting the warrant that's issued, and that's what the Fourth Amendment requires. And so in a complicated case where there's already a lot of paperwork being filed by police and prosecutors, following the Constitution here is actually something that's pretty easy.
Did you know IJ represents ordinary people free of charge as they fight back against government abuse? If you're looking for a rewarding way to support our work, consider becoming a member of our merry band of monthly donors and stand shoulder to shoulder with IJ's clients every month of the year. Monthly donations are convenient and cost efficient, meaning more of your money goes directly to our fight for freedom and justice. Sign up to donate today at ij.org/monthly.
IJ just scored a major win, holding prosecutors accountable for retaliating against our clients. Robert Reeves was one of the many innocent victims of Detroit's unconstitutional vehicle seizure program. When Robert decided to partner with IJ and stand up for his rights, prosecutors retaliated by filing bogus criminal charges against him, twice. Thankfully, a judge threw them out both times for lack of evidence. Because courts have given prosecutors near total immunity, it's almost impossible to sue them for retaliatory arrests. We knew a lawsuit against Robert's prosecutor would be one of our hardest cases, but IJ has a zero-tolerance policy for harassment of our clients. Now, the Michigan Court of Appeals has ruled that the prosecutor who brought charges against Robert does not get immunity. That's almost unheard of. Now, governments are on notice. Don't mess with Americans fighting for their constitutional rights. They say everything is bigger in Texas, and when it comes to educational choice, they're right. This last legislative session, Texas passed Senate Bill 2, the largest day one program for educational savings accounts in the entire country, giving families the chance to provide more educational opportunities for their children. Not only does this bill have universal eligibility, it prioritizes lower income and special needs applicants. This bill is a capital T-sized Texas victory for kids. We recently celebrated the one-year anniversary of IJ's Zoning Justice Project to protect and promote the freedom to use property. We've had great success in this first year with cases that have changed lives, like saving a private warming shelter whose city tried to cancel its permit just before a brutal winter, helping an Atlanta braider open her salon after a competitor got the city to block her permit, fighting against heavy fines imposed on a man providing a safe and secluded place for a family to live. Our advocacy has helped protect a vegetable garden in Florida, lobstermen in Massachusetts, an urban farm in Indiana, and a micro school in Arizona. Zoning strict rules on how people can use their private property makes us less free and less prosperous. We're fighting back, and this success propels us forward. Don't forget to like, subscribe, become a monthly donor at ij.org/monthly. Thanks for tuning in.